Hello and welcome to the first of e.law's 2016 Continuing Legal Education webinars. This webinar addresses the legal implications of cloud computing. Complete viewing of the webinar entitles legal practitioner participants to claim one continuing legal education credit in all states of Australia. I'm Chivers, CEO of e.law. The webinar is focused on the legal and practical issues which must be considered when contemplating or engaging in cloud computing. In the course of the webinar, I will cover cloud computing, definition and benefits of engaging in cloud computing, the practical risks associated with using cloud computing, the legal issues associated with cloud computing, privacy considerations, conducting due diligence for cloud services, security issues, regulatory compliance issues, discovery and disclosure issues. Before I begin, a little of the background of e.law and myself. e.law was incorporated in 1979 as a consulting service focused on applying technology to secure tactical and efficiency benefits in the management of evidence. At that time, evidence was typically filed as a simple paper chronology, with some subsets of evidentiary documents being produced for witnesses or to address particular issues. The technology of the day made it possible to create multiple indexes and to interrogate more than one index at a time. The capacity to bundle evidence by issues, to select from an issue documents or from an identified individual in a specified date range was an order of magnitude improvement on earlier processes. In the years since then, e.law has been the Australian leader in legal technology, participating in many of the milestone legal technology events. Today, e.law provides consulting and project management services in all Australian jurisdictions and cloud-based evidence review solutions. I joined e.law, then known as Systematics, in 1988. In conjunction with others, I hold a number of technology patents in evidence presentation and for the management of complex multi-purpose evidence libraries. What is cloud computing? Cloud computing is the practice of using a network of remote servers hosted on the internet to store, manage and process data as an alternative to keeping that data on a local server or personal computer. The key issues include separation of the computing infrastructure, typically both ownership and control, from the creator and owner of the data. Cloud computing can consist of both data storage and processing capability. It is offered in a variety of different forms. Infrastructure, first as a service, IaaS, is the most basic cloud service model. It enables an organisation to acquire a simple right to use the infrastructure of another organisation to run its software and store data for a service charge. e.law, when it engages with Amazon Web Services, does so on an IaaS basis. Amazon simply provides a processing capability of specified power and a data storage location. The software is loaded, owned, independently licensed by e.law. The data stored is similarly the property of e.law and/or its clients. The model is typically attractive because of economies of scale and the ability to rapidly expand limited capability to address very high levels of demand. In this model, the consumer has near complete control of the resources which are being rented. The second alternative is Platform as a Service, or PaaS. A PaaS contract opens the infrastructure model to development options. It provides a platform that allows customers to develop, run and manage their own applications independently without the complexity of maintaining infrastructure typically associated with developing and launching software. PaaS customers do not manage the control of the underlying cloud infrastructure, including servers, operating systems or storage, but they do control the deployed applications and settings within the application environment. Software as a service, SaaS, is the third typical model. In an SaaS model, users gain access to applications, software and databases. The cloud provider manages the infrastructure. It is effectively software and data storage on demand. SaaS is distinguished from IaaS and PaaS in that the user does not exercise management or control of the infrastructure. Neither does it undertake development. It simply uses existing software. e.law engages with Amazon and other services on an IaaS basis, and in turn engages with end users on an SaaS basis. These alternatives, while distinguished, are often combined to meet integrated business purposes. Microsoft, for example, provides Azure as an IaaS service, which is coupled with both PaaS capabilities and SaaS capabilities. Office 365 is an example of software as a service embedded within infrastructure as a service. Why would you or your clients want to engage in cloud computing? How does it work? In a progressively greater number of instances, business services are only available through cloud services. The accounting service Xero, the customer relationship management service, Salesforce, for example, exist only as cloud service provisions. At a lower level, the energy provider, Click Energy, will simply not contract with you unless you're prepared to have the relationship operate entirely paperlessly through internet services. I would expect this will be a growing commercial imperative. Traditionally, the attraction lies in the capacity to simply rent as much or as little computing capability and storage as is needed, sourced from a very large-scale, low-cost operation. Today, your client might require only 1 terabyte of storage to service 10 users, but tomorrow a new project comes online which requires 500 users and petabytes of storage. In the cloud, this change is typically achieved instantly by simply adjusting settings. The in-house alternative requires provisioning and cost at the higher than anticipated end and an expectation of significant delay while those facilities are acquired and commissioned. The user of cloud computing avoids almost all the traditional cost burdens. In the cloud, there is no capital cost for internal infrastructure, for software. There is little or no continuing cost for IT staff to manage infrastructure and licensing. There is no real need to provision against the expectation of growth. This applies to both storage and to the requirement for additional computing power. While there are some arguable security risks in cloud computing, which I will address later, in terms of the traditionally recognised risks, cloud computing is a dramatically more secure environment than any internal computing facility. Security is enhanced by remote location and highly regulated access regimes. Microsoft, for example, will not divulge the location of their Australian Azure facility. Redundancy of facility, of power, etc., is at the highest possible level with large-scale installations. Virtual access controls are maintained at current highest possible levels. I also like to use the expression herd security. If your client is using a facility applied by a large number of businesses, then it's comforting to know that issues will be shared through a large user population. This does not diminish the pain of failure, but it does increase the burden on the cloud computing provider to provide resolution quickly. Ultimately, cloud computing resolves to a dramatic increase in computing power and storage capacity, typically coupled with an equally dramatic decrease in cost. This is an attractive combination for any business. So, what are the potential downside issues? What do you need to consider when advising a client contemplating a cloud computing service? None of the risks in cloud computing are exclusive to cloud computing. The fundamental issue is that risks, while typically reduced, are in a cloud computing context outside the control of the owner, organisation responsible for the data. Security breaches and privacy. Intrinsic to the cloud environment is the transmission of data across public infrastructure into a public facility, which, while partitioned and controlled to a very high level, is shared by a large number of people and organisations and is accessible from any internet-connected location in the world. Even with the most rigorous of security frameworks, there are simple risks. Users often share passwords, allow publicly accessible PCs to retain access credentials, and/or use standardised passwords. The capacity to technologically protect against these types of risks is very limited indeed. In the most sensitive environments, a client will insist upon an air gap between devices in its network and public infrastructure. This is not possible in cloud computing. Loss of control over data in the cloud is necessarily controlled by the third-party service provider. In the context of a dispute with that provider, it is open to the provider, technically, if not legally, to have prohibit access to the stored data. I will deal with both the practical and legal methods to protect against this risk shortly. The risk of technical failure also in a cloud environment causing data loss is very substantially lower than the risk of data loss in a self-maintained environment. But, as with other loss of self-control issues, care must be exercised to ensure that both legal and practical alternatives are in place to protect data from malicious intervention or technical failures. I will deal with both practical and legal methods to protect against this risk shortly. It must always be contemplated that the cloud service provider may become insolvent. A clear understanding of the consequence of the service simply ceasing to operate is developed by your client, and strategies for this specific type of disaster recovery should be in place. The physical location of data is a significant issue. Onshore versus offshore storage. For many computer users, this is important. The physical location of data is a crucial requirement. Cloud computing providers are often reluctant or simply refuse to identify the physical location of their services. From some perspectives, this is an adjunct to security, but there are instances in which, either as a matter of policy or law, data is required to be kept within the jurisdiction. If your client is in this class, obviously, the cloud contract must be specific about the location of the cloud facility. Depending on circumstances, insistence on an inspection of the facility and provision of security documentation may be essential. In common with virtually all commercial arrangements, it is sometimes necessary to discontinue a cloud computing agreement. In the absence of clear provisions concerning contract termination, the cloud vendor is inevitably tactically positioned to resist the removal of data from the cloud service. Both the contract and practical provisions should be in place to minimise the impact of an acrimonious end to the contracted service. I will deal with this shortly. In summary, the key issues which must be considered when examining a contract for cloud computing, issues which are rarely adequately protected, include privacy, onshore versus offshore data storage, security of the data centre, loss of data, loss of control over the data, the insolvency of the cloud provider, disaster recovery, and contract termination arrangements. Due diligence inquiries in advance of the contract and confirmed by the contract is the key to successful cloud computing engagement. Cloud computing is inherently not significantly manifested by any physical artefact. Consequently, your client is more reliant on the contract and the vested interest of the cloud provider in delivering satisfaction than is the case if, for example, they were entering into a building contract. What should due diligence inquiry cover? References. What is the total scale of the facility being used? What users are prepared to endorse the quality of the service provided? Is there any comfort in herd security? Identify the location of the services and undertake an inspection. Document the security which is applied to the inspection process. If your client can obtain easy access to the facility, then the probability is that others likewise can obtain easy access, and security is likely to be less than is required. Confirm any regulatory obligations specific to your client concerning the location of data. If the service is offshore, is this acceptable to your client? Confirm the flexibility that your client requires and quantify cost variation frameworks to meet that flexibility. Are there practical measures open to protect your client's investment in data? Can data be routinely exported to storage, which is controlled by your client, and can that data be rapidly redeployed to an alternative facility? What insurances are accessible to your client in the event of failures? Are they sufficient to properly cover the exposure? The contract is important, but it is only an adjunct to practical commercial imperatives. I will return to its role and the elements it should cover shortly. I will now turn to some of the more difficult legal issues in cloud computing. I will cover the uncertainties associated with control of data, the physical location of data and jurisdictional issues, specific location issues, cross-border enforcement, specific privacy requirements. Ultimately, I will return to the contract. Is storing data in the cloud the same as storing records in boxes in a warehouse? No, it certainly isn't. Relatively recent cases take the position that electronic information is intangible and is therefore incapable of being owned. Ultimately, the media is a physical artefact which can be owned, but not its content. Its content is intangible, incapable of ownership. In Your Response Limited versus DataStream Business Media Limited 2014, the English Court of Appeal held that a database was an intangible asset and the law did not regard this as property. Accordingly, it could not be subject to a chosen action. Similarly, in Dixon versus the Queen 2014, the New Zealand Court of Appeal had to determine whether a digital video recording was property and capable of being stolen. The court said while the hard disk it was on could be stolen, the information stored on that hard disk could not be. Fundamentally, it appears that data in the cloud is at least often being treated as an intangible asset and is not afforded the protections that would apply if that data were recognised as intellectual property. Is this distinction likely to be specific to the type of data being stored? Some data, by its nature copyright material, for example, will be clearly protected by intellectual property law, while at the opposite extreme, data in the public domain will not be so protected. Who has jurisdiction over data stored in the cloud? In 2014, Microsoft and other US companies challenged a criminal search warrant, which addressed emails held by Microsoft in a data centre physically in Dublin, Ireland. The application was dismissed by Judge Loretta Preska on the basis that the real question addressed by the warrant was that of control, not that of location of the information. Although this judgment has been widely publicly reported, there is no formal citation. The indication at this time was that the decision would be appealed, but to date no outcome of the appeal has been reported. Jurisdictional issues in Australia. In Australia, there are specific limitations to the storing of data offshore. Specifically, APRA requires notification of any transfer of data offshore by financial services institutions. In addition, a significant number of government departments have blanket prohibition on the use of cloud facilities which store data offshore. It must also be kept in mind that remedies which are available in Australia may not be available overseas. Also keep in mind that data stored overseas will be exposed to the powers of the police and regulatory authorities in the jurisdiction in which the data is kept. The status of the data in the event of civil disturbance in the jurisdiction in which data is kept is also a practical matter of significance. Political stability is, obviously, highly desirable in the event that data is to be resident offshore. Cross-border enforcement issues. I'm not going to pretend to be an expert in international law and cross-border issues. For the purposes of the current discussion, it is enough to simply understand that privacy laws are dramatically different between jurisdictions, and that data stored in one jurisdiction, controlled by an entity in another, temporarily held in otherwise uninvolved jurisdictions, and prospectively made available to users in multiple jurisdictions. The opportunities for conflict are endless. I will deal later with the characteristics of some specific jurisdictions. And, as I said a moment ago, in some jurisdictions, privacy is a vigorously protected right. In others, the concept of privacy, in our terms, is effectively unknown. Ultimately, it is necessary to recognise that privacy offences are not consistent across jurisdictions, and that rights and offences in one jurisdiction will often not be enforceable in other relevant jurisdictions. I will return to Australian constraints on cross-border data flows later. Immediately, I'll focus on Australian privacy principles and law. At the risk of being obvious, our consideration of Australian privacy principles proceeds in the light of the jurisdictional issues that I've just covered. The Australian law and principles are set out primarily in the Commonwealth Privacy Act of 1998, most recently amended in January 2014. The Act defines personal information and broadly requires that personal information should be collected, managed, disseminated and retained only so that it meets specific purposes with the consent of the person who the information describes. Section 4 of the Privacy Act defines personal information as information or an opinion, including information or an opinion forming part of a database, whether true or not and whether recorded in a material form or not, about an individual whose identity is apparent or can be reasonably ascertained from the information or opinion. This includes biometric data, section 4, bracket 2, such things as an individual's fingerprints, retina prints, body samples, or genetic characteristics. Health is also protected and is subject to the Commonwealth Health Records and Information Privacy Act 2002. Schedule 1 of the Privacy Act sets out how most Australian government agencies and substantial organisations must manage private information. The principles set out in Schedule 1 to the Act can be made more specific by development of a code by organisations or groups under Part 3AA, but privacy codes must incorporate the principles set out in Schedule 1. Requirements specific to government agencies are extended by the information protection principles set out in Section 14. The first and most fundamental principle set out in Schedule 1 is that personal information management must be open and transparent. This includes the requirement that specific privacy policies should be established, which describe the information collected, how it is managed, and provide a method for free access to the information by the individual described. Other principles extend this basic obligation. Privacy Principle 2 requires that individuals must have the option of not identifying themselves in certain circumstances or using a pseudonym when dealing with an organisation bound by the Australian privacy principles. Principle 3 limits the collection of personal information to information which is reasonably necessary to meet a functional requirement of the organisation. The collection of sensitive information is treated at a higher level, requiring consent or specific legal authority. Principle 4 requires that unsolicited personal information outside the scope of valid collection should be destroyed. Principle 5 requires that the individual about whom information is being collected should be notified that the information is being collected. Principle 6 requires that information collected for a particular purpose should not be used for another purpose and must not be disclosed to any other purpose or organisation. Principle 7 deals with direct marketing, requiring specifically that collected information must not be used or disclosed for the purpose of direct marketing, except in circumstances where the individual who provided the information would reasonably expect that the information would be used for direct marketing. It also requires that if direct marketing is authorised by this exception, the individual must be given the option to request that the information not be used for this purpose. Other legislation also relevant to direct marketing activity includes the Do Not Call Register Act 2006 and the Spam Act of 2003. Principle 8 deals with cross-border disclosure of personal information, which I'll return to shortly. Principle 9 prohibits the use of government identifiers by other organisations. Principle 10 requires an APP entity to take reasonable steps to ensure that personal information is accurate, up-to-date, complete and relevant. Principle 11 requires that an APP entity to take steps to ensure that personal information is kept secure. Principle 12 requires an APP entity to provide access to information held by the person, the subject of the information. Principle 13 requires an APP entity to take reasonable steps to correct information that is found to be inaccurate, out of date, incomplete, irrelevant or misleading. It also requires that the entity should notify other entities of the correction. Beyond the foundation principle that the collection of private information should be open and transparent, two principles are of specific relevance to cloud computing commitments. First, Principle 8, which requires that an entity in Australia may only transfer personal information about an entity by an individual to someone in a foreign country only if specific criteria are satisfied. These criteria include, first, the presence of privacy protections in the receiving jurisdiction that are substantially similar to those in Australia. Second, that the individual consents to offshore disclosure. Third, that the disclosure is specifically authorised by Australian law, or the disclosure is necessary for enforcement-related activities. Second, Principle 11 requires an organisation to take reasonable steps to protect personal information from misuse, unauthorised access, modification or disclosure. What happens in the event of the breach of privacy principles? The Privacy Act provides for the establishment of the position of Privacy Commissioner with a range of powers to investigate and resolve privacy complaints. These powers include capacity to compel an apology, to direct a change of privacy practices, to make an order for access, amendment or deletion of stored private information, and in appropriate circumstances, the Privacy Commissioner can also make an award for compensation for injury to feelings, humiliation, etc. In 2015, 5 privacy complaints were decided by the Privacy Commissioner. In 4 of these complaints, a monetary compensation was awarded as part of the determination. The common law does not recognise a right to privacy. In Victoria Park Racing and Recreation Grounds Limited versus Taylor in 1937, Latham CJ took the position that any person is entitled to look over the plaintiff's fence and to see what goes on in the plaintiff's land. If the plaintiff desires to present this, the plaintiff can erect a higher fence. This position has, however, been contained to some extent where the interference is more substantial. In Groves v. Purvis, in circumstances described as stalking over a prolonged period, it was recognised a breach of privacy and constituted a civil action based on the actionable right of an individual person to privacy. In reaching this conclusion, the judge identified a number of elements which constitute an actionable breach of privacy. The act must be willful on the part of the defendant. It must intrude upon the privacy or seclusion of the plaintiff in a manner which would be considered highly offensive to a reasonable person of ordinary sensibility. It must cause the plaintiff detriment in the form of mental, psychological or emotional harm or distress, or which prevents or hinders the plaintiff from doing an act which she is lawfully entitled to do. International privacy considerations. As I said earlier, privacy protections vary dramatically between jurisdictions. It is probably reasonable to observe that there is a tension between the desire on the part of governments to protect privacy and the offsetting balance of a perceived need for access to private information to deal with terrorist and other criminal threats. In this context, and in the context of data residence and data use and control in different jurisdictions, the positions and the enforceability of positions on privacy are in flux. In the European Union, the European Convention on Human Rights provides a right to private and family life. Also, in April 2014, laws to compel retention of telephone communication records data were rejected in the European Union. In the United Kingdom, a 2007 authority confirmed there is no recognised common law tort of invasion of privacy in the jurisdiction, but the Data Protection Act 1998 does address data privacy issues in a manner similar to Australian law. Similarly, in Canada, there is no common law tort of invasion of privacy, but British Columbia, Manitoba, Saskatchewan, Newfoundland and Labrador each have provincial statutory causes of action for invasion of privacy. In New Zealand, the Court of Appeal has recognised a common law tort of privacy. In China, no personal data protection law exists. Neither has China entered into any treaty for data protection, but there is the Civil Code and tort liability law recourse for infringement of rights to privacy. In the United States, nearly all US states now recognise either a statutory right to privacy or a right at common law. These rights are, however, moderated by the US Patriot Act, which targets terrorism, and the Stored Communications Act. The Patriot Act is focused on terrorism. It requires the collection and disclosure of information and implements other strategies to prevent the transfer of money to fund terrorism. The requirements apply to any company with presence in the USA without regard to where the data is held. The Act is reinforced by a number of mutual treaties with other countries. The Stored Communications Act authorises the issue of subpoenas for criminal investigations to compel the disclosure of basic subscriber records for both telecommunications and social media accounts. This is supplemented in many instances by contract provisions in social media accounts, which make it clear that the data use policy allows the disclosure of information pursuant to a legal request both in and outside the US. Ultimately, as I said at the outset, protections of privacy, both legally and practically, are very significantly different from one jurisdiction to the next. Coupling these differences with the complication of separation of data residence and data transit and use is extraordinarily complex. This brings us back to the dominance of practicalities over legalities when contemplating a commercial relationship which includes cloud computing. I will now return to the practical and legal issues of entering into a commercial relationship for cloud computing. As I've said previously, the contract is important, but more important are the practical commercial provisions which balance the benefits of cloud provider and cloud service user. It is all too easy in a cloud computing relationship to create a complete practical dependence on the cloud provider. What to look for? How will the data be stored and in what format? A tension exists between the pressure for security and the pressure for accessibility. If the relationship breaks down, in an SaaS arrangement, data held in proprietary formats, even if it is not encrypted, becomes difficult, if not impossible to use, when it is separated from its host interpretive software environment. It is valuable to either insist on standardized data format, for example, ODBC, or if this is not possible, to ensure that there is an alternative method to get access to the host software in the event of the failure of the contracted cloud environment. Where will the data be stored? I have dealt with this previously, with the complications that come with jurisdictional separation of data from the users of data. These complications must be understood and the various risks must be accommodated by operational arrangements. Who has access to the data? Target users will be contemplated by the arrangement, but there are provisions that allow the cloud provider to restrict or prohibit access in the event of a dispute. Does the commercial arrangement allow or even require the provider of the cloud software or cloud service to have access to the data? Some software environments allow this. It may be possible to lock the software down so that nobody other than the ultimate users can have access to the data held by the system. If this approach is adopted, consider the risk that users might change and that credentials might be lost, with the result that the data can simply not be retrieved by anybody. Again, this is a balancing act. What other technical controls are required and who manages them? In all cloud scenarios, the cloud vendor has at least some level of control. It may be nothing more than the capacity to deprive the system of power, but even this is a serious threat if your client is dependent on the cloud provider for a mission-critical system. Higher levels of technical control exercised by cloud vendors expose the user to higher levels of risk, but the likelihood in a large-scale installation is the technical capabilities in the hands of cloud vendor will be more extensive and highly trained. Security in and around the data center, is it acceptable? At least on this question, there is a recognized international standard, ISO 27001. If the data center is independently accredited to this standard, you can with confidence assume all the recognized security exposures have been addressed. It is prudent to seek a copy of the accreditation document and review any security testing results. Visit the data center. A visit to the data center, or even a request to visit the data center, will be informative. In the event the request is refused, this might be taken as an indicator that physical security is maintained at the highest possible level. That, however, becomes a matter of trust. In combination with positive references from prominent businesses with substantial security exposure, this might be recognised as a positive attribute. The alternative, of course, is being granted a visit. If this occurs, procedures should be closely observed. What is the security staffing level? What records are kept of the visitation? Is the record keeping comprehensive? Are devices within the complex independently secured? Is there comprehensive power protection? Is it designed simply to facilitate a controlled shutdown or to support operation for an indefinite period? If practical, arrange a significant use of the system on a trial basis. In doing so, attempt to replicate live operation loads. Finally, but certainly not least, obtain a substantial list of referee users of the system or facility. Do not dismiss the value of herd security. If you know that when something goes wrong it will affect many users and substantial interests, there is a strong probability that the corrective action will be delivered effectively and promptly. These are intended to create practical commercial confidence in the capacity of the cloud vendor and certainty in the event that, for whatever reason, the relationship comes to an unplanned end. The contract is important, but reference to it most often occurs only when an intractable problem has developed, by which time the commercial viability of the arrangement has already failed. Legal issues in the contract, what to look for. As I've said a few times, the contract is important, if only as a tactical instrument in a difficult relationship. What are the things the contract needs to cover? Perhaps it is obvious, but is there a clear statement in the contract which describes the scope of the arrangement? Often it seems legal practitioners look closely at fine legal detail, but leave the description of what is to be provided in the hands of the client. The cloud computing equivalent of not obtaining a survey to ensure that what the client in a conveyancing transaction is buying is what they have inspected and think they are buying. There are many options in cloud computing. Is it a contract for infrastructure, for software, for support services, or for a combination of these things? Are the base changes clearly expressed? Are acceptable rates of charge for up and down scaling equally clearly expressed? Has the client a clear understanding of the upper and lower prospective levels of engagement? Is the term clearly expressed? What provisions are in place for damages in the event of interruption to service? Does the contract attempt to exclude the liability of the cloud vendor entirely, or limit the liability of the cloud vendor to the value of the contract or part of the contract? Should your client be insisting on liability for consequential damages? What support services are included? Is there a responsiveness guarantee? Are services different between different hours? If a range of hours is expressed, are those hours attached to a time zone that is appropriate to your client? Are the services that are likely to be required by your client? What provisions cover access to data in the event of various contingencies? Contemplated contingencies should include extended system failure, collapse of the cloud vendor business, substantial dispute between cloud vendor and your client. Practical access to data should be fundamental to virtually all commercial cloud computing arrangements. In my view, this requires a routine of the data in usable form, being placed in the hands of your client or a third party. Does the contract provide for routine backups? As above, backups to the facility which are controlled and accessible to the client are preferable. It should be confirmed that the backups create a recoverable system. Integrity of the data, the format of the data should be specified and understood. Its integrity should be routinely tested. Location of the data. The contract should identify the physical location of the data and specify or limit the capacity of the cloud vendor to relocate the data. What are the provisions for termination? Be on the lookout for conditions that impose substantial fixed terms and/or periods of notice for termination and costs associated with removal of data from the cloud service. Always keep in mind that at the point of termination, the cloud vendor has little or no reason to assist your client. Insolvency events must be contemplated to ensure that, as far as possible, ownership of the data, software, or other components always remains with the user of the service. The contract should contemplate insolvency, including, as far as possible, compelling delivery of data and all other things necessary to provide business continuity for the cloud client. At a practical level, this is achieved by ensuring that a current version of all relevant software is routinely delivered to the cloud client or an escrow agent, with a provision which allows for the use of that software by the client in the event of the insolvency of the cloud vendor. Similarly, the contract should provide that the cloud client is regularly provided with a copy of current data. The capacity to recreate the software environment held in escrow and to restore the retained data should be tested regularly. It is a standard risk that software versions and backup data formats can become incompatible. The contract and the practice should require that backup versions of software and data are maintained in parallel. Data retention. How long will data be stored before it is deleted by the vendor? Is there a charge for retention? Data retention policy should be set out in the contract. Intellectual property rights. The contract should confirm that intellectual property rights are not disturbed by the cloud computing relationship, unless this is specifically intended. Simply, the IP and software remains with the software vendors, and the IP and data is typically vested in the cloud user. In the case of custom software development or software modification, the contract should be explicit as to the ownership of the resultant intellectual property. This should be a matter of common sense, but often boilerplate contracts will, in the event of a dispute, purport to vest rights to data in the cloud provider. These provisions should be refused. From the reverse perspective, it is desirable that in the event of failure of a SAS business, that at least the right to use the subject software for business continuity should vest automatically in the cloud client. Disaster recovery procedures should also be set out in the contract if they require the participation of the cloud vendors. This issue is minimised if there is a tested recovery mechanism entirely within the control of the cloud user. Provisions for migration of data should contemplate movement from facility to facility and from one software platform to another. In every case, the use of data format standards will simplify and minimise migration issues. The contract should also be as specific as possible, describing security measures which are applied by the cloud vendor. But keep in mind that in some circumstances, public documentation of procedures applied may in itself prejudice the security measures. It will sometimes be the case that a cloud vendor will boldly refuse to discuss the specifics of security procedures. In this case, the substance, reputation, and herd dimensions of the cloud vendor may be sufficient to give your client the requisite confidence. As I indicated previously, security is a pivotal issue which should be addressed at a practical level outside the scope of the contract. Security pressure points vary depending upon the nature of the cloud computing relationship, but the key issues which should be considered are physical security. The dimensions of physical security I have already dealt with. It will sometimes be the case that a cloud vendor will refuse a request for inspection, but depending on circumstances, this may not be a negative in the prospective cloud user's consideration. Data security should consist of a mix of hardware and software elements deployed at the data center. Encryption is a process of encoding data flows so that they cannot be read in the course of transmission. The encoding process occurs at the source and decoding occurs at the point of user access. The encoding process imposes a load and consequently is not always used, and on some occasions use is limited to only sensitive points of transmission. For example, passwords and other authentication processes may be encoded while other data is sent unprotected. There are also many levels of encryption and other authentication processes which rely on keys. Methods of recovering data in the event of key loss or the risk of losing data in the event of key loss must be understood. Penetration testing should be undertaken regularly and should address both the capacity for an anonymous third party to reach, read and damage data and the capacity of a recognised user to step beyond the specified scope of permissions which are attached to that user. Audit services. Certification of the facility to ISO 27001 standard is a strong indicator that recognised risks have been addressed. However, the prospective cloud user should confirm that the accreditation of the cloud vendor has been undertaken by an independent accrediting authority and is current. The contract should commit the cloud vendor to re-accreditation on a regular basis. I will address briefly now the elements of the ISO 27001 data security standard. ISO 27001 accreditation commences with a detailed assessment of risks. This includes assessment of the impact of data being damaged or destroyed, the scope for malicious manipulation, and the impact of data being released to unauthorised people or organisations. The prospective risks are many and varied. At the risk of being obvious, some data in the wrong hands has nothing more than limited commercial implications. In other cases, lives may be at risk, or at the extreme, national security may be compromised. Perhaps an obvious example would be the disclosure of the identity of criminal informant witnesses. The effectiveness of such witnesses and their personal security depends entirely on identity protection. Obviously, security parameters in the cloud and elsewhere must be able to accommodate the risk. Very high-risk data is, at least at this point, rarely made available through cloud computing arrangements. Traditionally, such data is kept in systems which are, for want of a better expression, air secured from all public computing services. The second part of ISO 27001 accreditation looks for policy that recognises the risk identified and establishes management commitment to containment of those risks. This is the process of balancing security risk and commercial or other benefit. Banking transactions conducted through the internet cannot be without some risk of financial consequence, but the cost-benefit of acceptance of those risks is substantial and ultimately accepted by participants in the transactions. Other aspects of ISO 27001 require that information security processes have effective documented governance, that information assets are identified and classified recognising risks, that participating human resources have identified joining, operational and most importantly processes to manage separation from the organisation. A high exposure risk is the disgruntled employee leaving the organisation with security credentials intact. Physical security is also a key requirement, but I've dealt with this sufficiently previously. Communications and operations management systems must be properly documented. This includes documentation of the configuration of both physical and virtual components. Access controls are users restricted to only those parts of the networks which are necessary for the performance of their specified function. Do software development methodologies require the construction of each modular element to include reference to the security governance and model prescribed? Incident management. The document procedure should anticipate information security incidents and define responses which are appropriate to foreseeable risks. The procedural base should contemplate mechanisms for business continuity. As touched on before, a procedure or procedural alternatives should be available which minimise or eliminate interruption to business in the event of a failure or security breach. All security frameworks must identify external requirements, both legal and procedural, and map processes that satisfy these requirements. Moving beyond this general ISO 27001 requirement, the prospective Australian cloud user must identify and manage compliance with a number of specific regulatory requirements. The residence of financial data outside Australia must be approved by APRA. An organisation contemplating moving data into the cloud to a centre outside Australia must notify APRA and demonstrate that the cloud service provider has put appropriate risk management procedures in place to protect sensitive data. The prospective cloud user must also secure guarantees in contracts with offshore data hosting companies that APRA will have access to hosting facilities in order to conduct site visits at their discretion. They must also ensure that arrangements are in place for the continuity of operations following loss of cloud services. These requirements have not, however, been an insurmountable obstacle. The Commonwealth Bank and other Australian financial institutions are known to have deals with Salesforce.com, for example, a cloud-based CRM vendor with no Australian data centre. The prospective cloud user must also ensure that the cloud service meets the requirements for the Australian Privacy Principles 8 and 11, which require that the host jurisdiction should have in place privacy and security protections which are essentially to the same or a greater standard as those which are in place in Australia. I will turn now to the issue of disclosure obligations which attach to information in the cloud. In common with conventional discovery, the key issue which drives discoverability is the question of possession, control or custody of the data. Even in conventional disclosure questions, the issue of ownership has never been paramount consideration. As discussed above, the available case law focuses on control and has tended to dismiss the physical location of data, and there is little doubt that the terms of the cloud contract may determine both ownership and control of data. While there is no case law that I am aware of to determine the position, it is likely that Australian courts would be prepared to order the disclosure of data resident in foreign jurisdictions where that data is controlled by an Australian entity, and to order the disclosure of credentials to access data resident in the cloud, whether it is physically located in Australia or elsewhere. All disclosed evidence, even if obtained from the cloud, must be examined in accordance with the Electronic Discovery Reference Model, which sets out a process that identifies information governance policies to identify items of prospective evidence relevance, running through analysis and production of a concentrated relevant subset. The EDRM model must be applied to all data in an organisation which is the subject of a disclosure discovery obligation. Social media, by its very nature, is a creature of cloud computing. The tests for its disclosure are the same as those which apply to conventional information, whether held directly within an organisation or within commercial cloud computing relationships. Although there is no known Australian case, constraints on the disclosure of social media at this time appear to be more practical than legal. Corporate social media is not difficult. It is accessible and is in the control of the entity, in the same way as more traditional, if I can use that expression, cloud-based systems. Content of relevance on Twitter, Facebook, LinkedIn and YouTube, for example, is all clearly subject to any disclosure obligation. Often, however, relevant evidentiary content is now being found in the private accounts of individual employees. The extent to which a corporate entity exercises control over these accounts to bring them within the scope of a discovery order is arguable on a case-by-case basis. In US proceedings, judges have considered the issue of the disclosure of private social media on a number of occasions, but no definitive path has yet emerged. A number of alternative paths have been tested. In 2011, the judge in Offenbach v. Bowman privately reviewed information in advance to determine if disclosure was required. In 2010, the judge in Barnes v. US National friended a party to determine if Facebook posts were relevant. In 2009, the judge in Largent v. Reed required parties to turn over physical access, usernames and passwords for social media accounts to the other party. In 2013, the judge in Leicester v. Allied Concrete Co. fined both a party and his lawyer for cleaning up a Facebook page to remove damaging posts and pictures. I'm sure it would be wise to counsel prospective cloud user clients to take care with data, both corporate and private, which is stored in cloud computing repositories. There is no doubt it won't be long before these issues are forced to the attention of Australian judges. To conclude, cloud computing is now past its infancy, and coupled with the explosion of data collection, cloud data is taking over the information world. But at this point, the law related to it is largely unsettled. There are more questions than answers. The position is aggravated because the technology and its application is changing daily. The commercial imperatives that are driving prospective cloud users are substantial. In mild cases, substantial cost benefit is tending to make the non-cloud user non-competitive. In more dramatic circumstances, there are businesses which are entirely refocused on delivering services which are now only possible by utilisation of the cloud. In the context of unsettled legal positions, these commercial imperatives, commercial protections must be practically rigorous. For the lawyer providing advice, this often reduces to a focus on due diligence activities which might, in more traditional contracts, have been adequately addressed by the formality of a contract. Expressed differently, the risks of the cloud-based business must be understood, and the paths through those risks must, as far as possible, be planned in advance. The contract is important. It should clearly describe the expectations of both the cloud user and the cloud provider, reducing or eliminating misunderstandings. It should also document what happens in the event of foreseeable difficulties and provides a foundation if difficulties develop which have not been foreseen. The lawyer providing cloud computing advice cannot confine his or her activity to settled law. We must be prepared to understand and legally interpret the practicalities of the transaction being entered into. e.law is a specialist consulting legal practice that has focused on digital evidence and legal technology issues since 1979. Members of the e.law team are resident in Sydney, Melbourne, Brisbane and Perth, and are available to assist legal practitioners and others nationally. Thank you for taking the time to listen. We will shortly open the chat room for any questions or comments you may have about what has been discussed during today's webinar. Before we do that, please note the webinar slides will be available to download via email over the next few days. If you require a CLE CPD certification, or if you have any questions or comments, please email e.law on info@elaw.com.au or call 1300 30 30 80. The webinar will also be uploaded on the e.law video gallery and our website and YouTube channel. You are welcome to submit comments in that forum as well. I will now take your questions via the chat room feature on your screen. Thank you again for listening.